Hello and welcome everyone to our webcast this morning or this afternoon noon in relation to avoiding the pitfalls in the salaried engagement space. I'm Lewis Izzo, Managing Director of Sydney Workplace at Australian Business Lawyers and Advisors. And with me is Tamsin Lawrence, Senior Associate who heads up our Melbourne workplace practice. Tamsin, how are you today?
I'm very well. How are you, Lewis?
Very good, very good. Tamsin and I have already had a very robust exchange before we've even started on all the pitfalls and intricate aspects of wage compliance, so I'm sure we'll be ready to go. Thank you everyone for joining us. This topic is becoming more and more of a headache for everyone involved. Headache for business, headache for us in navigating the issues, headache in explaining it because it can be quite complicated, headache in dealing with businesses that are scratching their heads as to why we have such a complicated wage compliance framework. But it is important that we help business get their head around the annualised salaried space. If you are paying employees on salaries, of which many businesses are, it's important you understand what you're obliged to do, what you're recommended to do, and if you're not doing certain things, the fact that you may be exposed to quite significant penalties these days in relation to that. So we want to get you across the problems that you need to deal with and some solutions, and hopefully we'll navigate that in the next 59 minutes. Tamsin has an iPad over there for live questions, so if you have questions, please send them through. We'll try and make it through the hour without coughing and spluttering. Some of us are recovering from illness, but so far so good, which is excellent. The agenda. We're going to start off with just taking you through some of the recent changes to wage compliance laws. There's been a big injection of teeth, if I can call it that, into the penalty provisions. Tams is going to take us through that. We're then going to talk about your record keeping obligations as an employer, because in our experience, many employers are not complying with these obligations, particularly when it comes to salaried staff. So we want to get you through that. We then want to talk about your options for engaging employees on salaries, the different ways you can do it, and how compliant or non-compliant those options might be. Going to talk about salaried options under awards as well, and new approaches that we're looking to kind of create to make this whole world simpler for business. And then we're going to talk a little bit about reasonable additional hours at the end, as well as dealing with questions. So that's a summary of the topic. You're ready to go?
Yes, quite a bit to cover.
Well, we might then kick off. I'm going to hand over to Tamsin to talk to us, I should say, in relation to the new wage compliance laws. Hand it over to Tamsin.
Thank you. We now have a wage theft offence, technically. I don't usually like to use the wage theft term, but it's technically now in law. And it also covers super, one of the last minute kind of exemptions. For those who may have thought super was carved out, one of the last minute changes of the Greens was to slip back in super. So we now have this offence. It sits in the realm of the criminal law. So probably the first time for most people outside of maybe the state of Victoria that have now had to potentially face the risk of criminal penalties. Safe to say, though, I don't think most people should perhaps be as stressed as they might be about this. It is quite a high bar in order to engage in this behaviour. It has to be an intentional underpayment. We're not looking for the accidental underpayments or accidental misclassification. It has to be something that is intentional. And that is the criminal standard of intention. So it's not, it's where we have to go to the federal criminal law to figure out what that means. But it's something that is either expressly authorised or tacitly authorised or impliedly authorised by the behaviour of the entity being a company or any individual managers who might be involved. Now, as you can see from the slide, there are some really significant penalties for companies if they engage in this behaviour, up to almost $8 million, or this thing about making it 3 times the underpayment. But we might come to that at the next part when we look at penalties, because it's a new way of figuring out the penalty amount. It's not now just a set figure. We can now sometimes triple the amount of the underpayment to figure out the amount we have to pay back. For individuals, they can face personal imprisonment as a result of this, or a fine of almost $1.5 million. So a pretty significant penalty, but I don't think it needs to be something that everyone's too stressed about. If you're actively trying to do the right thing and you're not intentionally underpaying people, for most people, they should be fine. Important to remember, though, that this is something that will be done by the DPP, but probably on the basis of Fair Work Ombudsman reports. So if you are going down that investigation route, complying with what the Ombudsman asks, being as helpful as possible, will probably, hopefully, lead to them not handing whatever report it is over to the DPP.
Yeah, so just two things on that. To your last point there, Tamsin, the Fair Work Ombudsman will have the capability to investigate underpayments of a criminal nature. So that is, they might form a view, much like the police would in a criminal kind of event circumstance. They'll comply an investigation brief as to whether or not they have formed the view that there has been criminal underpayment, that is intentional underpayment, and then they will forward that brief on to the CDPP, who would actually run the prosecution. The second element, just to emphasise something Tamsin said, is that there was a lot of talk about reckless underpayment or kind of negligent underpayment being something that could give rise to criminal liability. That has not come to fruition, which is really quite comforting. So you do need to have knowledge of the contravention and intend to not make that payment in order for criminal liability to attach. So that's something, but it still means that boards and businesses will be treating this a lot more seriously.
Yeah, and particularly where you become aware of something. So once you become aware of a certain type of underpayment, if you then continue to operate in the same basis, then you might be in one of these situations where they might say you've suddenly slipped into this intentional behaviour. But honest mistakes, as the Minister told us in his press club address on this issue, are not intended to be captured by this change. Now, we do also maybe just touch on the few things just previously back on the previous slide. There are these two kind of safe harbour type protections. So if you do cooperate with the Ombudsman and you're a large employer, there are meant to be some strings attached to that, but cooperation is meant to mean that they won't make that referral to the DPP. And then we're meant to see this voluntary small business wage compliance code, which would help small businesses in the same situation, yet we're all kind of still hanging back and waiting for that to happen. And whether or not that does even is created, we don't know. Watch and see in that space. And I must just say, from a Victorian perspective, we've had some of these criminal matters down in Victoria. They are an absolute nightmare. I think the level of stress that comes with them is something unlike anything else we've experienced in employment law. So definitely not a pleasant experience if you do face something in this new wage theft or super theft space.
To the penalties.
We've seen some huge increases to the penalties. If the last few years weren't enough, we've seen them now be increased fivefold. Looking at civil penalties up to the $1 million range for serious type contraventions. Typically, though, they're going to be around the 460, but that's for each individual contravention that somebody might engage in. Now, there's also, as I mentioned just before, there's also a change to where a contravention involves an underpayment, the possible fines that you might face as a result of that. There is that flat figure for each individual contravention, but there's now a kind of alternative, and if an applicant wishes to pursue this, they can seek that the court hand down a penalty that is 3 times the quantum of the underpayment. Now, obviously, that doesn't necessarily mean that's going to be the figure that they hand down, but it makes the potential underpayment, particularly in workplaces where the figure might be quite large. Consider something like the recent underpayments of Woolworths, for example. They would be looking at a potential fine there of over $1 billion when you times that by 3. So definitely something to be careful of if you do end up in this space. The other thing to note is, and we put it at the very bottom here, proportionality used to be something that used to be kind of factored in these decisions, but the High Court recently handed down a decision in 2022 that said that shouldn't be a factor in determining the penalties in these types of matters. Other things like deterrence.
General and they talk about general and specific deterrence. So general deterrence is to deter everyone from underpaying by setting examples through businesses that don't do the right thing. And then specific deterrence is to deter that business because of whatever specific conduct it engaged in, particularly if there's a level of recklessness about how they went about things, then there's a need to specifically deter that business for its failings in relation to doing something like this again. So they look at both generally and specifically deterring this behaviour as part of the makeup of a fine.
Absolutely. So that brings us to the end of what we're looking at in terms of the new criminal potential realm that we might end up here, and then obviously significant salaries. Now, how does that all play into what you're currently paying your staff? Well, I think we all need to perhaps ask ourselves, how are we actually setting the salaries that we might be paying our staff? Do we know if we've got a buffer between what we're required to pay under, say, a minimum award and what we're actually paying in a salary? Do we know what limitations we have? Do we know how far our salary actually stretches? Do we know if we have someone work, all over the weekend or excessive overtime hours, that we're paying enough? And in this new realm of higher penalties and potentially criminal sanctions, it's definitely something I think people need to turn their minds to, need to look at their payroll operations, look at how they're setting their salaries, because setting and forgetting perhaps has far greater risk than it ever has before.
Yeah, and this is particularly for HR people who've just come into a business or for businesses that have been operating for some time. This kind of blue band there on your screen, the set and forget. I mean, there's probably lots of people in businesses that we come across that have had a salary set for a particular type of activity or job, might not have been set by the current owner, might not have been set by the current HR manager, but it sits there. And what we're saying to business is anyone checking, is anyone reconciling to understand that the salary being paid is actually sufficient to compensate for what's payable under the award for all hours worked? And if you don't have a regular reconciliation process in place or a regular checking arrangement in place, that's where you end up in some areas of hot water. And one of the things that we're encouraging businesses to think about is in a risk kind of sense. The lower the salary, the higher the risk, obviously. And so you really need to kind of traffic light your different salary ranges. And it might be salaries above a certain level. You say we can have a much less regular or much higher level checking process on them because we've got a high level of confidence they're okay. But then once you get to certain other levels, you actually need to have quite a high level of focus on them and scrutiny to ensure that these salaries don't dip below what's required.
Yeah, absolutely. And thinking about where's your salary come from? Have you got award-covered employees? Are they covered by an enterprise agreement? Is there something that's playing into what the salary should be, or have we just got non-award covered, non-enterprise agreement covered employees, which are a lot easier? We don't have any requirements to cover those, and perhaps, as you said, in that lower risk category of people to consider. Now, a bit of a lesson from our good friends at Best and Less. We thought we'd just put this up as a little example. Best and Less, they weren't paying effectively their managers appropriately. They'd done this set and forget. They were paying a salary. They didn't realise perhaps how much overtime their managers were doing. They were working weekends. They were working later hours, early mornings, and they self-reported to the Ombudsman. So they did an internal audit and they figured that they had underpaid their managers all across the country. I think the underpayment came, as is on the slide, to around 5.2 million, and that was a figure that they had to pay back. I think on average is about 7,000 per employee, so not a huge amount, but when you kind of quantified it across the country, a far greater figure. Also, they were kind of put over hot coals by the Fair Work Ombudsman because of a failure to keep appropriate records. So they didn't keep records of overtime, which I know we're going to cover very shortly, and they didn't actually make proper records, let alone keep a copy of them. So as a result of that, they were forced into an enforceable undertaking. They had to make contrition payments of around 200,000 and obviously had to back pay all their staff. So,
and you'll see yet again what we're seeing here. I think Woolworths had a similar experience. Is it's not the kind of time and attendance staff, the wage staff that are on an hourly rate that are being underpaid. So you would have had at each of these stores a retail shopfront worker, you would have had people stacking shelves in the back of the store. Those workers were all paid sufficiently because they had an hourly rate. Yeah. Someone was tracking their clock in and their clock out. Someone was tracking their overtime. And so their kind of time and attendance staff, if we call them that, or their hourly paid staff were all fine. It's that first level of management that are on a salary. There's an assumption they're more senior, they're paid more, and that's where we've seen a lot of kind of businesses slip up. Yeah. It's the commencement of the salaried band, that's where the problems
and
arise.
the buffer just wasn't big enough here. And I think we're going to come to a discussion a little bit later. How do you set that buffer? How do you make sure it's big enough? And also, one thing I failed to mention about best and less is a part of the undertaking with the Ombudsman is they had to publicly disclose all of this to everyone, including putting up notices in their actual stores to notify effectively customers that they had also broken these laws. So I think it's that public damage. Obviously, you can go read about this in the newspaper. Whilst they did the right thing, they backpaid everything. The repercussions that came from that in terms of public damage, along with the actual amount they had to pay back, was
They're
quite
being
significant.
named and shamed by Tamsin
Exactly.
right now.
Here I am adding them on a slide deck. So, yes.
So that's kind of the kind of important piece about ensuring that your salaries are set right, and hopefully Tamsin's kind of put the fear of everything into everyone. We then move to your record keeping obligations, and this is an important element of setting the scene as well. Under the Fair Work Act, the Fair Work Act says that you need to keep records of certain things. Those certain things include a range of matters that kind of employees' leave details, employees' salary. You've got to keep a record of any averaging arrangement for our ordinary hours of work. But one of the most important things to bear in mind is the following record keeping obligation, which is that if a penalty rate or loading, however described, needs to be paid for overtime hours worked by an employee, the employer needs to keep a record of the number of overtime hours worked during the day and when the employee started and finished those overtime hours. That's quite a significant imposition, because when you have employees on an annual salary, you might have an employee who is a particular grade level under the retail award. You've decided you're going to pay them well above the award, $80,000 a year on a salary. You might think, well, they will never actually work that many hours so as to hit that particular salary level. Yep. I'm comfortable with the amount I've set. That doesn't exclude you from the record keeping obligation, because under the award, for every hour over 38, there is a penalty rate or loading that applies, even though your salary is more significant than what they would receive. And what the record keeping obligations require is, even if your salary is more than enough to cover their hours, you need to keep a record of every hour over 38.
So it's not just reasonable additional hours that
not just particular additional hours or hours above their salary. If an award applies or an EA applies that sets a different rate for an hour of overtime, whether it's more than the daily maximum number of ordinary hours, so more than 7.6 or 8 in some awards, or more than 38 over a week, somewhere there needs to be a record of that extra hour that's been worked, or those extra 3 hours that have been worked. In our experience, a lot of employers using annualised salaries are not doing this. They're managerial staff that are being left to manage their own hours of work. There's a level of trust that the salary set is sufficient, and no one is actually tracking any hours of overtime that have been worked each week. Yeah. So what you have is a record keeping breach. Tamsin's mentioned that the fines have already gone up quite significantly for all breaches. Every single record keeping breach attracts a $469,000 fine. And so those businesses engaging people on salaries need to start thinking about this type of issue as well. And where you have a casual or an irregular part-time employee, you actually need to keep a record of all of their hours of work. Now, for casuals, that won't be a problem. As I said, most employers are keeping a record for people paid hourly because they need to know
how much they pay.
what to pay them. The problem's coming up for people on salaries, really.
So you're going to need to put in place some kind of time in, time out system, or is it just letting them know they need to record all their overtime? Like, what's the solution for people to...
Look, it's going to depend on the business what your solution is, but you need some way of capturing it. Whether you're going to put the onus on the employee of keeping a record each week for hours above 38, whether you're going to introduce a Bundy clock style time in, time out, which I know a number of businesses with employees on salaries are reluctant to do. So you need to think about what works, but you need an arrangement whereby you can, either the manager can monitor it, the employees being required to keep a record, someone needs to be keeping a record, and most businesses aren't doing this at the moment. So that probably brings us into your options for engaging people on salaries. We've got 6 options up there. the 6 is really a webcast topic all in and of itself. But the first is you can look to use the modern award annualised wage arrangement provisions. Some awards have specific annualised wage regimes that you can adopt. Now, Tamsin's going to take you through them. They are very cumbersome. In our experience, businesses have been having a lot of difficulties applying these regimes.
Yeah.
And so, whilst certainly it's something you should explore, I'm not surprised if most of the viewers turn away from that option, because we've seen, just in our experience, that businesses are struggling to grapple with the complexity of these wage arrangements. Mm-hmm. The second option is to actually use common law set-off clauses to set a salary for an employee and say, well, the salary we're paying you is in satisfaction of all our award obligations. And we'll talk through what that looks like next.
Mm-hmm. And that's probably the one most people are doing, maybe without even knowing.
Doing it well or doing it badly, many are doing it. And the reason I say well or badly, it depends how good your set-off drafting is, but most people are doing that. More and more, we're starting to work with business about saying, is there a better way of doing this? And that's where award exemption rates is a solution we're starting to look at, and we'll talk you through that. Outside of that, there are IFAs, less used, guarantee of annual earnings, available, not commonly used.
Yeah, only thing about that I think we just need to mention is if you're going to do the guarantee of annual earnings, you need to be paying over the high income threshold. So you need to guarantee that you actually are going to be paying over the guarantee. And you can't just get someone to sign the agreement and be like, yeah, I guarantee it, but I'm going to pay just slightly under, or maybe even a lot under. It actually has to be over that 167,500.
Yeah, which is a much, much higher salary than a lot of the annual salaries we're talking about. I mean, if you're paying above the high income threshold, the reality is it's very unlikely there's going to be an award underpayment, because the number is just so much higher than the award numbers. So the guarantee of annual earnings doesn't really help for those types of businesses that are looking to use salaries where there's a risk of compliance. So we'll talk through each of these options briefly. You can obviously use an enterprise agreement, but enterprise agreements come with their own world of complexity and regulatory intervention. You do run the risk of greater union involvement in a business once you start bargaining. So I wouldn't go down that path without properly considering what's involved in bargaining for an EA. So let's take you through the first option, annualised wage arrangements. Tamsin's now very passionate about these arrangements.
No, they are very cumbersome. It's fair to say if you use this arrangement, you'll get a lot of certainty. I think it's probably the only arrangement you can use where you can, to some extent, I would say, set and forget and come back to it at the end of the year. For every other arrangement, technically at law, each pay period you need to be paying the correct amount. This is the only way that you kind of get a leave pass, and they say, we'll let you underpay for a little while as long as you, what they say, reconcile it at the end. But we'll take you through all the exact minutiae of it in a second. But for the what awards can actually use this arrangement, we put all 22 on the slide. If your award that your employees are covered by is not one of these 22, you don't have the ability to use this particular arrangement. You can use one of the other 5 options, but this one in particular is not available. Now, every award has relatively similar but slightly different arrangements in them. We're going to cover the overall kind of categories of things that operate to make an annualised wage arrangement work, but I would say you definitely need to go and look at that specific clause in your award before you start putting in place an arrangement to make this work, because they all have slight tweaks to them.
And obviously the biggest award to call out there is the Clerks Award. So for all those businesses engaging clerical employees, administrative, reception-based employees. There's 1.9 million clerical workers in the country, I think. The Clerks Award does have an annualised wage arrangement clause, but there's certain other awards out there as well where it may be of use. But for all businesses, it is available for clerks, and I think you're going to use the Clerks Award.
Yeah, I think we'll discuss the Clerks Award. I mentioned a couple of the others. Just one thing to note though, if you do have an award in that 22, you don't have to use the annualised wage arrangement. You could say, no, I want to put that to the side. I still want to use, say, the common law arrangement, which Lewis will cover in a second. You're completely entitled to do that, and the Commission made that very clear when they reviewed these arrangements and tweaked them back in 2020. They said, no, it's fine. You can continue to use common law if you like. You just have to be doing that in a lawful manner. So let's get into the minutiae of it. We put up the annualised wage arrangements clause for the Clerks Award. We might flick back to this when we look at the specifics of how these work. But as you can see, it's quite a wordy clause. There's three real parts to it, but we're going to break down on the next slide, if we move to that, Lewis, the four kind of components of what you need to have an annualised wage arrangement in place. First things first, this arrangement can only be for full-time employees. In each of the awards, there's no ability to do this for part-time employees. That doesn't mean you can't have an annualised wage, an annualised salary, for a part-time employee. You can, you just can't use this arrangement to get you there. But if you do have full-time staff, you can, and the first thing you're going to need is a written agreement with the employee to have this arrangement. Now, for some awards, you're going to actually need the employee's agreement to do it, but for others, you can simply say, send them the agreement and say, I'm setting this up, put it in writing to them. You don't actually need the employee to agree to that arrangement, but it does need to be in writing. In that agreement, you need to actually spell out what the salary encompasses or includes. So that would obviously set down the minimum, whether it be daily or weekly rate, and how you've kind of hopefully times that by 52, whatever it might be, to get to the figure that you'll be paying the person. You're then also going to need to think about everything else that you're required to pay under the award. So that could be overtime, penalty rates, allowances, annual leave loading. Some awards set out the specifics of what are allowed to be in it. If we flick back to the casuals clause, as you can see, it's quite detailed. It allows you to cover everything that's listed there at 18.1. You can include all of those if you wish. For some awards, there's slightly less that you can include, with some things still carved out, like, for example, public holidays for some are still carved out. Once you've done all of that, you also need to set what is called outer limits. We'll come to that in a second. Just two other things, though, I did want to mention is some awards actually set the minimum amount that you have to pay above the salary. So take, for example, hospitality. Under the Hospitality Industry Award, you have to be paying a minimum of 25% above the minimum rate in the award in order to set this annualised salary. In other awards, like the Clerks Award, there is no percentage. You can set it wherever you like. You obviously have to be above the minimum rate, and one would think it's going to need to be a little bit on top of that.
Well, you've got to set it at the number that you're satisfied is going to be sufficient to offset the types of hours they're going to be working.
Absolutely. And that will become clear when you have to explain to the employee all of the things that you're encompassing. So in setting that, they'll be aware and you'll be aware of what it's meant to encompass. Secondly, some awards allow employees to actually terminate this agreement. So they have to give 12 months notice, but there are only a handful that allow that. Now, here comes the tricky bit, outer limits. This is definitely the most difficult part of the entire annualised wage arrangement, and probably the reason, safe to say, most people aren't using it. But in setting this agreement, you have to set an outer limit for the amount or the maximum hours that an employee is going to do it for overtime and for any penalty hours that they're entitled, that they're going to do. Now, that doesn't mean they can't work outside of the outer limits, but if they do, they actually have to be paid at the time that they do that work. You can't rely on this reconciliation point where we pay them everything we might have stuffed up at the very end of the year or that we might not have paid yet. We have to actually pay them at the time.
So you have your annualised wage arrangement that's designed to capture a whole series of hours you've incorporated into a bucket.
Yeah.
But then outside of that bucket, if they go beyond it, you have to set out that they will then be entitled to penalty rates at the time that they work those extra hours. So you have a salary arrangement that doesn't actually cover all hours of work. It covers a defined bucket, but when people work outside of that outer limit bucket, you need to pay extra, which does add a layer of complexity, obviously.
Yes. Now, for some awards like Clerks, if we flick back to Clerks, it just says you need to set them, and this is at 18.1b there with I think we've got it highlighted in bold at IV. For the Clerks Award, it doesn't require you to set, you can set whatever outer limits you like. If you wanted to set the outer limit at 30 hours of overtime and 30 hours of penalty rates, you're entitled to do that. Now, obviously, it might be a bit strange to set those at a different rate to what you've said when you've set out in the agreement the basis upon which you've set the annualised salary, but technically you can. But in some awards, take for example again hospitality, it actually sets and tells you what the maximum are that you can do. I think it's like 12 and 18 or something like that.
And so you'll see there the clause Tamsin's referring to, just to identify the complexity here, is it says you need to identify the outer limit number of ordinary hours which would attract the payment of a penalty under the award, and the outer limit number of overtime hours which they may be required to work in a period without being entitled to extra payments. So you set that outer limit amount, but then beyond that, extra payments apply.
Absolutely. So the way it kind of works in practice, if we maybe, let's say in the Clerks Award, we set it at 18 overtime hours and 12 penalty rate hours. If for some reason 1 week you end up having an employee work for 20, that's above the 18 outer limit, you would need to pay them those 2 additional hours of overtime at that next pay period. You can't wait and say, oh no, I paid them an annual salary, I'll reconcile this at the end, it's all good. You have to pay them above the outer limit. But in most awards, you get to pick that outer limit. So if you wanted to, you could make it pretty broad and just say, I'll reconcile it all at the end. Or you could keep it nice and tight and say, I'll pay everything that I need to in excess, so I'm not given a big shock at the end of the year. Now, if we move to the next slide, these are the 2 additional obligations that come with it. The first is in relation to time and record keeping. It's quite similar to kind of hopefully what most people are probably already doing for their non-annualised salary staff, in the sense you need to record their start and finishing times, and you need to record any unpaid breaks taken. You obviously also will need to record any overtime that they do outside of the outer limits. In accordance with what Lewis mentioned earlier about needing to record any overtime that's payable. You also have to get an employee to sign, and this can be electronically or done in person, to confirm the hours that they've worked after any pay period or roster cycle. So you can do that. If they're filling in their own timesheets, that's probably going to be enough to say that they've kind of reconciled and agreed to it. But that process has to be undertaken so that the records that you're using to then reconcile at the end of the year, everybody's kind of agreed to. Now, once you've done that, the last thing you have to do is at the very end of the year, and the end of the year is the 12 months from when the employee started, you have to do this reconciliation process. And that's when you say, okay, I've set this salary, I've paid this salary, have I got any underpayment that exists? Do I need to make anything good? Have they worked so much additional overtime or penalties that my set rate of salary was not sufficient? And if it's not, you have to make it good within 14 days. Now, the reason I'm slightly partial to this is because it technically allows you to underpay someone for a period of up to 12 months without having to, lawfully. You just have to make sure you reconcile it at the end. Whereas every other method that exists, there is some element of risk that for a period of time you might be underpaying in a method that's not considered lawful. Now, I know it's an overly cumbersome way to get there, but if you're super risk averse and you just want to make sure that you're doing it by the book, this would be the most lawful way to do it.
So Tamsin's done a good job of selling the benefits of the annualised wage arrangement, and this is the cause for our robust discussion before we jumped on the webcast. I echo her comments. I think the difficulty businesses are having is once you've gone through in terms of the protection mechanisms, A, you've got all these written agreement requirements. B, you've got to set an outer limits, and you've got to set when people start to work extra that attracts immediate payment. Then C, you've got to go
Get the signing off
to the next safeguard, which is signing off of hours recorded every single pay period.
Yeah.
And then D, you've got the annualised annual reconciliation process at the end anyway. What a lot of businesses are saying to me is they're finding it very complicated.
Yeah.
They're finding it very hard to do that for each and every employee. Tamsin's right. If you do all of that, you are as compliant as you could be, and you will have a very good regime in place that will protect you from wage theft laws. The problem is, in my experience, all the businesses we're talking to just simply aren't doing this.
Yes. And at this point, you probably might as well just be paying them hourly based on what they're entitled to. Like, the level of obligation is probably at the same level, almost if not higher in some senses.
So what are the alternatives? If you do find that is too cumbersome, is there another way to go about it? The most common thing that businesses are doing is using what we call a common law set-off clause. So they're going to an employee and they're saying, we will pay you a salary in satisfaction of our award obligations. That salary, we're satisfied, is high enough to deal with all of the entitlements you're likely to receive in a pay period or in a year. And what they do is they provide, and the drafting is very important here, but they provide drafting that says the salary we are paying you each pay cycle is sufficient to satisfy all of your monetary entitlements, whether that to be to base rate of pay, penalty rates, overtime, leave loading, so on and so forth.
Yeah.
What this does is it doesn't extinguish any of the award entitlements. They all exist. They're all payable separately on an hourly rate. But what it's saying is the amount we're giving you every pay cycle is enough to cover all those amounts.
Yeah.
And your typical common law offset clause will also say that if we pay you slightly more in one pay cycle than we need to, we can use that to satisfy if there's an underpayment in, say, the subsequent pay cycle or something like that. And we're going to come to that because it's very important that your drafting addresses that if that's what you're intending the salary to do. Couple of things. For this to work, your drafting of your offset clause must be quite tight. It needs to be very clear what it's capturing. If it's too generic, you will have scenarios where a court might look at it retrospectively and say, it wasn't clear that your salary was meant to cover all of these award entitlements. And that's what happened in that case we've referenced up there, Simone Jade, Stewart and Next Residential. So need to be very clear as to all the different types of entitlements that are covered. The next thing that's extremely important, obviously the salary does need to be set high enough. Like, you actually have to be realistic about this. You can't pay someone 10% above the award
Hope for the best.
and then require them to work 10 overtime hours a week. It's just not going to work. You need to ensure your salary is realistic. The third element is you can put in drafting, as I said, that said if we have a shortfall in one pay cycle, we can rely on subsequent overpayments to satisfy that shortfall, say in the same calendar year. That might ensure that the employee is ultimately paid enough. The difficulty, as Tamsin will only be too fast to tell you, is that you will still have a technical breach at some point. If there was a pay cycle that they weren't paid enough in, the award requires them to be paid the amounts owing under the award each pay cycle. So really what you have is a scenario where you've underpaid in, say, March, you fixed it in April, but for a 4-week period, you've had an underpayment. And
the law technically doesn't allow that. Technically.
It doesn't. And that's a deficiency in this option. Most businesses are using this option because they're struggling to grapple with the annualised wage arrangement, but you need to be across that is the deficiency with the common law offset clause, is that you might still pay enough over the year, and that might be enough to get you through, but it does raise the possibility of a breach in 1 month or two if your pace, the salary payment wasn't enough in a particular pay cycle.
Particularly if you have people who might do more seasonal work, so they might have 9 months of the year that are pretty standard, then you might have a 3-month really busy period over a seasonal or holiday period. For those employees, you've just got to hope that they don't flag that they feel like they've been underpaid during that period, because obviously it's probably going to be flattened out over the rest of the year, but for those people it's probably more problematic than if you've got relatively consistent employees who might just ebb and flow month to month. It's probably less of a risk or a concern.
And look, that's what you're going to have to grapple with when you're looking at your various options. So that's the common law set-off. And the one thing I'd say as we leave that is if you are using that approach, just absolutely every employee needs to have received, whether it's in their contract or a separate document, a set-off clause that's explaining how that's operating. It doesn't need to be too long, might only be a couple of paragraphs long, but it needs to have the right content.
And also making sure that set-off clause is properly drafted. There's no point having one and then it being deficient, you're leaving out allowances, you're not mentioning overtime, and then you can't use it and rely on it in the end.
Agreed. So they're the two main options. Because of the deficiencies in the common law set-off that I've talked about, we've really started to explore a better way of doing this. And this requires perhaps some movement in the Fair Work Commission as well. But we're looking at exemption rates now as a different approach or a different solution. What's an exemption rate? An exemption rate is where an award will say if you pay X amount above the award, you don't have to worry about the award entitlements. They are extinguished. They are no longer payable. You don't have to do any of the reconciling of the annual wage arrangement. You don't have to do any of the outer limits. You don't need a set-off clause. As long as you pay the exemption rate, all other award obligations fall away.
So it's like the guarantee.
It's like the guarantee of annual earnings, precisely. The guarantee of annual earnings is incredibly helpful and incredibly helpful in avoiding all of these headaches. The difficulty with the guarantee is it's so high. It's at currently $168,000 per annum. Exemption rates might be less. In the hospitality award, there's an exemption rate for managers at 25% above the minimum award rate. If you pay 25% above the minimum salary for a manager, you're exempt from all the award obligations. That's a very beneficial exemption rate for business, and one I would certainly encourage hospitality employers to look at. We are acting for Business New South Wales and the Australian Business Industrial in the Clark's Award to introduce a new exemption rate for clerical workers. What we're looking at is an arrangement whereby if a clerical worker is paid 55% above the weekly rate, that will cover 50 hours work per week, regardless of how many hours the employee works. If the employee was to work more than 50 hours, at that point you will then need to keep a record of any hour above 50, and they'd be able to be paid at double time of their award classification. But that's not going to happen that often. The reason we've struck the exemption rate at 50 hours is to buy a really meaningful number of overtime hours each week. And what we're seeing in terms of the attraction of this provision is a business can actually go forward with certainty, with a level of confidence saying, I will pay a little bit more, I'll pay 55% above, but then for this managerial level of employee, I do not then need to worry about any of the award, overtime or payment obligations. This is the type of thing that will provide some level of comfort to people engaging middle managerial employees. It's not going to work at the lowest levels because that 55% above might be too high, but it will work for a number.
But the trade-off of the admin is surely going to be, like, even if it is 55, the amount of cost and time, you've seen how difficult it is to do the annualised wage arrangement, and then the risk that comes with doing the common law. This does seem like the perfect solution.
So we're looking at pursuing this in the Clark's Award. There's other awards that would obviously be crying out for this type of solution as well. Banking, finance, insurance industry would be a great target. There's a lot of people in that industry that are award covered, but will be paid well above award. This would just extinguish needing to worry about the monetary obligations in the award in that industry. Retail's another one that's probably a good target as well. So we're going to be pursuing this for Business New South Wales and ABI. Anyone who's interested in it, please reach out. I assume our contact details are going to be at the end of the webcast. Reach out if you want to hear about it, if you want to help contribute, because given the difficulties associated with the first two solutions we've put forward, this could be another way. And we're going to be pushing this particularly hard over the next 12 months to try and unlock some of the complexity around the salary wage compliance.
And when you look at the higher penalties, you look at the potential criminal elements that we now have in this space, it's such an easy way to then say, I'll pay a little bit more for all of that risk to just melt away.
Now, I think we can't have this whole discussion without also talking about the NES.
Absolutely.
And the way all of this interacts with Section 62 of the Fair Work Act. So all of our discussion today has been predicated on an assumption that you can have people work extra hours, as many hours as you like. That's not quite how the world works. There is a provision in the Fair Work Act, very rarely litigated, but there is a provision that says that employees can only be required to work additional hours that are reasonable in the circumstances. And what's reasonable will depend on the circumstances of every single case. Section 63 of the Act sets out the factors to be considered when having regard to whether additional hours are reasonable or not. Those factors include risk to employee health or safety, the employer's personal circumstances, the needs of the workplace, whether people are receiving overtime payments for those hours, whether notice is being given to the employer, by the employer of the need to work the additional hours, any notice given about the employer's decision to refuse, usual patterns of work in the industry, the nature of the role and its level of seniority, and so on and so forth, and anything else that might be relevant. So in any particular scenario, even if you're paying employees more to perform extra hours, they might have a right of refusal. Having said that, if you are paying them more and you've given them a set-off clause to say, look, this is on the expectation that you will be available for additional hours, that's going to help demonstrate that the extra hours you're requiring to be performed are in fact reasonable.
So can I have an employment contract that says that somebody works more than the 38-hour maximum?
You can. You certainly can say that someone's contracted to work 44 hours, which incorporates ordinary and some additional hours. They can agree to that contractually. You can have a clause that provides compensation for that. if later on the employee says, well, I don't think this is reasonable, they could test that. But it doesn't mean that your provision is unlawful.
No.
It will help guide the application of this test as to whether the additional hours were ultimately reasonable or not.
Yeah.
But there isn't a prohibition on having that type of clause in your contract. And as I said, it will help you with this test.
Yeah, because most will have the 38 plus reasonable additional. But if you knew they were automatically going to be doing 2 every week, you could make it 40.
That's right. Now, before we move, we're going to talk about common mistakes in a moment. Before we do, I think it might be, and we did promise this in our advertisement for the webcast, I think we're going to talk about how this all interacts with the right to disconnect as well, Tamsin.
Yeah.
Do you want to just give us, an idea? I mean, do you think there's going to be some relevance to this kind of offsetting clauses and what you incorporate in payments when it comes to right to disconnect as well?
I think it's definitely going to be forefront of employees' minds. I think for the first time ever, there's been high publicity, perhaps a little bit of misrepresentation by the media as to what employees' rights are. The right to refuse is only on the basis that the request is unreasonable, and I think that reasonable element of things, which looks very similar to this test, about what factors are at play, how much the person is being remunerated above, are all going to come into question with this right to disconnect if you have employees that start to push back. Now, obviously, there's probably going to be some probably very highly remunerated employees who are never going to say, oh, I've got a right to disconnect, but those ones in that middle band or people who are just scraping above the award, they're probably the people who are going to start to say, you're not remunerating me for this additional time, which might lead to conversations that might come about because they think they have a right to refuse anything after 5 o'clock.
And so, if you were to put in your offset clauses or your salary provisions that there is a payment that incorporates working outside of normal hours, office hours, etc., and they're being compensated for that, that may then help in any discussion if ultimately employees turn around and say, well, I'm not responding to certain matters outside of work hours. Now, the right to disconnect is its own topic, which which is going. I'm sure we're going to have a lot of updates for businesses about that in the weeks and months ahead. Importantly, it's not a prohibition on contacting people outside of work hours, but it does confer employees an ability to refuse to respond outside of work hours if the refusal is reasonable. What Tamsin's saying is, well, if you're paying them extra, it might feed into what is or isn't reasonable.
Yeah, and particularly given the right to disconnect is such an easy thing for employees to challenge in the commission. For an employee to challenge their wages, it's a far more cumbersome, far more higher threshold, different court they need to go to. But if they can turn around to the commission and say, hey, I'm not being remunerated for these additional hours, I'm being emailed at 10 p.m. at night and being expected to respond to it, it's going to open up a whole discussion around this. So you want to be able to justify your position, you want to be able to point to your contract, point to what someone's agreed to justify the contact you're making with them.
All right. Common mistakes. Are you leading us through this?
I think we're doing this one in tandem. The first one is simply using a base salary. If you're simply using a base salary to pay someone and you're not factoring in any of those additional payments, overtime, penalties, allowance, annual leave loading, then you're probably in trouble. Don't set and forget. It would be my other kind of thing around just using that base salary. We know that they're typically moving every 1 July. So if you have award covered employees and you're setting and forgetting, you're probably going to be in trouble every year. So make sure on that 1 July you sit and look and think, have I set the salary at the right rate? You're probably going to do, consider changes to wages every year anyway. Just match it up at the same time.
So I'll take the next one then, based on your hint. Reasonable additional hours, not calculating overtime rates. So yes, you've got people working extra hours. You haven't factored in that those hours don't simply get paid at the single rate time, but there might be time and a half the first two, double thereafter. And whilst I'm at it, going to the next provision, what people tend to forget is that awards have monetary and non-monetary entitlements. So everything we've talked about today is about monetary entitlements. It's about, do you cover the overtime? Did you cover the leave loading? Did you cover the allowance? What we haven't talked about is some awards have minimum break type provisions or minimum number of rostered days off each 7 days or whatever it is. These things are non-monetary. You can't contract out of them. So you need to remember that even if your salary is sufficient to satisfy the payment obligations, if an award says they need 2 consecutive weekends off every 4 weeks, you
Yeah.
still need to do that too. And a failure to do so will be a breach and will give rise to one of those very scary penalties that Tamsin talked about at the beginning of the day.
Yeah, and with breaks, it's going to be the similar idea that, say, for example, it says someone must have a minimum of 10-hour break or something between shifts. If you then bring them back the next day, then it's all overtime. And then you might get in trouble in terms of whether or not your annualised salary is enough. So they're all things you've got to factor in. Again, I know you're going to say I'm going to sell the annualised wage arrangements, but if you are looking at those, some of those clauses are a little bit different. They've given you a little bit more leeway in terms of the hours someone can work without penalties applying, for example, in some awards. So I would say if you are going down that path, have a particular look at what is changing, but also consider it in terms of every other requirement that you need to meet within the award. Should I now take the next one?
Why don't you go?
Don't take a one-size-fits-all approach to every employee. Whilst there probably are some employees who are, working the same shifts, the same hours, just because someone has the same job title as someone doesn't necessarily mean all of the same provisions are going to apply to them. So setting everyone at the same annualised salary might actually put you in hot water, because you might have somebody who might do a significant amount of overtime or work later hours where penalties are going to apply. And if you simply set and forget the same annualised salary for those people, you might end up in trouble with a bunch of employees that you might not have thought about. Considering you took 2, I'll take the next one. Hopefully we've covered enough around adequate records, but it's probably one of the areas where most people perhaps aren't doing the right thing at the moment. So get your house in order in that respect. That might mean you need to look at your payroll systems, making sure that they're recording the right information, or maybe, as we discussed earlier, maybe putting a greater obligation on some of your employees to record overtime if you're not currently doing that.
And to round it out, failure to reconcile payments, either pay period by pay period or at the end of the year, that's the whole set and forget problem. We've got people setting salaries and then looking at them again. I think we might jump to the questions.
Yeah, great idea.
So did you want to, I think Tamsin's in charge, but I think we had 1 or 2 that came through before that you could also
Yeah, I might
fire
cover those
off.
just to kick us off, if that's all right. We've had a question about what about employees who are not award covered or not enterprise agreement covered? How does it work for them?
So that's helpful to kind of draw attention to that. So for people who aren't award or enterprise agreement covered, you're in a much greater space, much more breathing room, because if you're not award or EA covered, the only obligations to pay the national minimum wage. The national minimum wage is set at a particular minimum safety net level, provided your salary is sufficient to cover that hourly rate, then you don't have to worry about overtime, you don't have to worry about loadings, you don't have to worry about allowances, because none of them apply for employees on the national minimum wage. So it's a much simpler exercise for those employees.
Yeah, definitely. I think you mentioned earlier that whole risk profiling. They're probably your low risk profile. It's anyone who's award or EA covered. They're the ones you want to look at first up. I've got a question around overtime and bonuses. Can bonuses be used to cover overtime?
So, excellent question. This comes down to your set-off clause again. When you pay the bonus, what are you saying it is in satisfaction for? If you are saying it is in satisfaction for your award obligations with respect to minimum rates, then you could use it for that purpose. But it would need to be made clear in their contract or in their, if there's a bonus incentive scheme, etc., would need to be made clear that that is being used to pay for these entitlements. And in absence saying that, you won't be able to rely on it, because bonuses, generally people will assume that they're discretionary payments on top. But if you want to use it for another purpose, you need to make it clear in advance that that's what that payment's being used for. Now, one of the difficulties with relying on the bonus is it might not be paid each year. And so that means you can't always call upon it, but you can use it if you've set out that that's what it's going to be used for.
Yep. Now, the next question is something that we lightly touched upon, but it's about a question about the hospitality award and the 25% how the 25% exemption might work when calculating a salary. I think this goes to exemption rates. So I think the question is, how does that, do you just pay 25% above and then you're done and dusted? You don't need to calculate the salary, you don't need to set out what someone's earning?
So provided you're clear that you're paying them the salary, I would reference the award clause that they're being paid a salary of X, which is 25% above, pursuant to clause X of the award, because I can't remember the award clause off the top of my head, then that would be sufficient to attract that provision, which then exempts you from a range of other award obligations under that award.
Yeah. The next one are about, should all employees, including executives, submit a timesheet that needs to be approved? Who needs to do this whole overtime thing? Who doesn't? I think this is what this is.
So, I mean, technically, if your employee is award or EA covered, and they have these various obligations about minimum base rate of pay, overtime amounts, penalties, loadings, allowances, you need, the moment they work over the minimum number of ordinary hours in a day or over 38 hours in a week, the record keeping obligations require a record to be kept. And so you would need a record of some kind, a timesheet of some kind, unless you've got an annualised wage arrangement in place.
Or a guarantee.
Or a guarantee of annual earnings, really.
Yeah, or you're using an exemption.
Or you're using an exemption rate, which gives you liberty up to the whatever the exemption covers, correct?
Yeah. Let me just pull up another one. Oh, a question about how to annualise salaries work for part-time employees. I know we very vaguely touched on them because we can't use the annualised wage arrangement for them, but how does it work common law?
Well, you can implement an annualised salary for a part-time employee, and you can say that the additional payments are to satisfy these extra amounts. I think the difficulty with part-time employees is where you're varying their pattern of work. You just need to be conscious that in most awards, overtime kicks in if they work above their agreed pattern, but then if they agree to vary their pattern of work, it doesn't attract overtime. It can be worked at single time rate. So you really need to look at your part-time employees separately and understand, do we have an agreed pattern of work? When they vary their hours, are we varying the agreed pattern so that we don't trigger overtime, or are we actually content to pay overtime for those extra hours? You need to do a bit of a deep dive on your part-time in your award, work out what those obligations are because they're very specific and unique to part-time, and make sure that the practice you have in place for part-time is consistent. If you're okay with paying overtime for every hour they work above their agreed pattern, that's fine. But if you're not, do you have a mechanism in place for varying their agreed pattern of work in writing each time? And that's something that you should certainly take as a separate action item.
Question about placing the onus on employees to record their hours. The question is there an onus then on the employer to make sure that the employee is actually recording their hours?
There may well be. I don't think you could simply just say, we asked them to do it once.
And they didn't do it and blame them.
And they didn't do it and blame them. You'd need to monitor that employees are complying.
The next question, again, in relation to record keeping, which is a great one. Do we need to record all start and finish times or only the start and finish times whenever someone works overtime? If someone isn't covered by an award, do the Fair Work Act record keeping obligations still apply? Perhaps to the first part about start and finishing times.
So the answer is no.
Unless they're under an annualised wage arrangement.
If they're under an annualised wage arrangement, the answer is yes. If they're not, the record keeping obligations do not say you have to keep a record of start and finishing times. What they say is, for every overtime hour, every hour that attracts an overtime penalty under an award or EA, you need to keep a record of those start and finishing times of the overtime.
But recording start and finish times might help you get the record of overtime.
That's right.
By its very nature. And the next part about that, if someone isn't covered by an award, do the Fair Work Act record keeping obligations still apply?
They do, but for instance, to take your start and finishing times example, you won't have to record start and finishing times because if there's no award and there's no EA, that record keeping obligation about keeping hours of overtime and start and finishing times of overtime won't apply.
Yeah. Now one about annualised wage arrangements, which is great. Can the outer limits be set so high?
My voice goes.
Yeah, can the outer limits be set so high that if the employee worked those hours, the agreed salary is insufficient? It won't be insufficient. You could set them so high. We had a discussion before we went on air about whether or not you could set them at a different rate to what you've set out in the agreement that you sent to the employee. Technically you can. It would seem a bit odd, but you could set it so high that you know that they're never ever going to go outside the outer limits. But bear that in mind, that means that when it comes to reconciliation time, you might get quite a surprise because you're still having to record the hours that the person works, so you're going to have to calculate their overtime, their penalties, and that could be quite substantial.
Because remember, the salary still needs to be sufficient to match what they would have paid had they worked under the award for the year.
Exactly.
that's that reconciliation piece. And
It
so
just allows you to underpay them for a period of time and then
rectify
then
it.
fix it at the end. Bearing in mind some of the awards do set the outer limits. So some of them do say you can't go beyond 18 hours and 12 hours, I think, in hospitality. I think restaurants might be quite similar. There's a handful of them that do. So I would check that before you just set your own outer limits at the, at
But
30
Tamsin's very
and 40
passionate about this
Call me.
notion, so reach out to Tamsin. She's very
I
keen
think it
to
is
set-
definitely possible to make it workable, but yeah, it's going to depend what award you're under.
Probably got time for one more.
One more. We might go back to the ones that are written if that's okay, just because I don't want to jump too much over these ones. Where award-covered employees are entitled to shift loading, is it best practice to show this separately? Or can we simply offer a salary of $100,000 and say it's inclusive of all applicable allowances and loadings?
So you can do the latter, but what you want to make clear in your set-off clause is exactly what you have in contemplation. It's in satisfaction of base rate, all separately identifiable loadings, penalty rates, overtime. If you call them out in that nature by subject matter, you should be fine. You don't have to say it incorporates the 12.5% shift loading, but I'd be calling out that it incorporates all loadings or shift loadings payable under the award. Something
particularly as awards are varied, you want to be a bit careful that you don't be too specific to the extent that then something changes in the award and then it isn't capturing what you hoped it captured.
Yeah, agreed. So look, hopefully that's been of some assistance. It's a very complicated field, but given how many businesses are employing people on salaries, it's something you have to grapple with. We've got a whole heap of additional material out there at the moment for businesses. So we've got IR reforms and e-guides on our website where you can find a whole heap of information about the latest IR reforms. We've got some training and other webcasts available as well. So encourage you to avail yourself of all the info on our website. If you need to reach out, we've got our contact details up there.
Particularly for audits, I think in this space is probably the big one.
Yes, absolutely. Happy to assist with all those types of arrangements to help ensure that you are paying the right amount and that your provisions, whether they're contract or policy documents, in place are actually sufficient.
Yeah, get those set-off clauses checked.
That's right. Thank you very much today. We made it through the hour so thank you for your contribution and thank you everyone for joining us today. Really, we'll be around next time.
Yep, see you soon.
Bye.